At about 8 o'clock on the morning of the 20th of May 2013, a Malaysian Airways flight touched down at Sydney Airport. A man called Jason McKell was keenly waiting its arrival. McKell was the movements manager at a freight company operating out of the airport and was interested in some of the cardboard boxes in the aircraft's cargo hold. The label said they were from Bangladesh and that they contained adhesive material for making T-shirts. Around lunchtime, McKell grabbed his iPad to check the progress of the boxes through the airport. The tracking system showed they'd been picked up by a driver working for his company. McKell called the driver and directed him to remove any mention of the boxes from his manifest and to sit tight. He was on his way. Soon McKell parked his blue ute at the side of the road and walked towards the stationary truck. At about 1:30 p.m, McKell and the driver began unloading the boxes and placing them in the back of the ute. Job done, McKell drove off. He didn't get far. He was stopped by police just around the corner. A search of the boxes revealed 15 plastic pails, or buckets, filled with a substance laboratory tests would later confirm as pseudoephedrine, an illegal precursor chemical used to make methamphetamine. There was 66 kilograms of the stuff, enough to make McKell and his co-conspirator millions, enough to send them to jail. So what does this 2013 Sydney drug bust have to do with the plight of Katia Piliotis? Everything, as it turns out. I'm Richard Baker, and this is episode 5 of The Confession.
Well, to understand McKell, you have to understand what happens in criminal trials and what the judge's role is.
Melbourne Law School professor Jeremy Gans is talking about the 2019 High Court of Australia judgment in the case of McKell versus the Queen. After McKell was arrested, he was tried and, like Katia, sentenced to a long jail term. McKell's lawyers appealed unsuccessfully but persisted, and eventually the case found its way to the country's highest court. To explain why any of this matters, Gans starts by telling me a bit about how criminal trials usually run and the role of the judge.
After the prosecution and defence have given their addresses to the jury, the judge gives what's called a summing up, and it does a couple of things. The judge tells them what the law is, what the definition of murder is, and what some of the rules of proof are.
Then at the end of a trial, a judge will go over the main facts of the case and what the prosecution and the defence have argued. Often, they will also proffer some interpretations of their own. In fact, Gans says that in Australia until recently, judges had quite a lot of leeway to say what they thought.
The judge wouldn't flat out say, I reckon this person is guilty, but they would often comment on particular witnesses and say, well, that didn't sound like a very credible argument. And the judge would then always say, but that's for you, that's not for me. It's your call, you're the jury.
The prosecution case against McKell and his co-accused was solid. 66 kilos in the back of a blue ute. It should have been a slam dunk case. But the judge hearing McKell's case had strong opinions about the value of some of the arguments being put to the jury by McKell's defence barrister, and he made them felt. He also made controversial remarks about how the jury might view certain matters where the facts were in dispute. In cautioning the jury not to be swayed by his views, the judge referred to his, and I quote, entitlement to express a view. By December 2018, the month Katia was found guilty by the jury in her fourth trial, the High Court was weighing up whether the judge presiding over McKell's case was in fact entitled to have said the things he did. And on 13 February 2019, the court handed down its ruling.
When they finally said, first of all, it was an unbalanced summing up.
The High Court found the judge's comments were unfair to McKell. It ordered his conviction be quashed and a retrial held. But the 5 High Court justices weren't done yet. What they said next would upend Australian legal precedent and change everything for Katia Piliotis. Professor Gans again.
Then they said at the end, but we also think that this practice of judges commenting on the facts basically needs to stop. They said that it used to perhaps make sense that a judge would give their own opinion. Back in the time when everyone assumed jurors were pretty dumb and not very worldly and the judge was bringing a lot of wisdom into the courtroom, but those times have passed. And secondly, there used to be a time when judges were thought to have a right to comment, that was part of their role, that they were allowed to give their view. And the court said that they don't have a right. Their sole job is to do what's fair. So the High Court said this practice just needs to stop.
The timing of the Mikel decision, after Katia's conviction but before sentencing, would prove a huge stroke of luck for Katia, though she didn't know it yet. Just like the judge in Mikel's drug trial, the judge presiding over Katia's fourth trial, Justice Coghlan, had expressed some strong views.
The judge had said some pretty startling things to the jury.
We heard a couple of them in the last episode. I mentioned something that happened when Katia's barrister was cross-examining forensic scientist Stephen Fowler about the possibility a fingerprint on Elia's front door hadn't been properly captured. Justice Coghlan interjected.
Oh, this is even more boring than the other bits of your cross-examination. But go on with it. It's going nowhere, is it?
As for Katia's claim in the prison phone calls to her family that there had been another person with her at Elia's house that day, Justice Coghlan, whose words are being voiced by an actor, told the jury the forensic evidence didn't support her position. And he went further.
And this again might be a comment from me. It does not seem to fit very well with the possibility of what the accused first says about, I was there with someone else. Well, whoever that someone else is, it would not seem possible that it was Susan Reddy.
These may seem relatively minor details, but small details can have a big impact. We know that Sue Reddy was the centrepiece of Katia's defence. Sue had confessed to killing Elia to her carer, had described their sexual transactions, and had described a possible weapon. But Justice Coghlan wasn't buying it. In fact, the circumstances of Sue's alleged withdrawal of her confession to Detective Ryan really didn't matter, he told the jury, because by then the police had already ruled, or would soon rule, her out as a suspect. Plus, he said, Elia appeared to be the one controlling the relationship between him and Sue, even if, as claimed by Elia's godson-in-law, Seif Ayed, the old man had voiced some fear about a crazy woman in the months before his murder, it probably wasn't Sue.
All I am suggesting to you is there is not much evidence to support the proposition that it was Susan Reddy.
Up until the High Court's Mikel decision, Katia mightn't have had any grounds to appeal her guilty verdict, certainly not on the basis of Justice Coghlan's comments. But the High Court's decision changed all that. Now her legal team applied for leave from Victoria's Court of Appeal to challenge her conviction. Not that Katia was getting her hopes up. After 4 trials, she knew better.
Even when something positive happened, I still found it difficult at times to be positive or to get hope back, because I became so used to things going wrong.
And there was a real possibility they could. Overshadowing the good news of the Mikel decision was another daunting prospect. Like Katia's defence team, the prosecution had also applied to the Court of Appeal to protest Justice Coghlan's sentence of 19 years with a fixed period of more than 15. Except the way they saw it, it wasn't tough enough. As for Mikel, he and his co-accused are back inside prison. They both pled guilty at a retrial in November 2020. Mikel will be eligible for parole in 2025. On the 14th of May 2020, just as Melbourne and its citizens were emerging from one COVID-19 lockdown, unaware they would soon enter an even longer one, Dermot Dan QC appeared before the Court of Appeal Justices Terry Forrest, Richard Nile and Philip Priest. Dan, who doesn't look like he's lost much fitness since his time as a premiership-winning footballer with Melbourne's Old Zavarians in the 90s, argued for Katia's conviction to be set aside. Just under a fortnight later, the justices returned their verdict. We've had an actor voice their published findings.
The judge's comments added force to the prosecution case and undermined the applicant's defence. They were not necessary. In our opinion, there is a real risk that the comments may have unfavourably influenced the jury's consideration of the defence case.
The Court of Appeal quashed Katia's murder conviction. It left it up to the Director of Public Prosecutions whether to take Katia to a fifth trial, noting that although the prosecution case was strong, a conviction wasn't inevitable.
Katia Paliotis always said she didn't do it, and thanks to a judge who said too much, she's no longer a convicted killer. It's now up to Victorian prosecutors to decide whether or not to pursue a murder charge against Katia Paliotis for what would be her fifth Supreme Court trial. The woman who was staring down 19 years behind bars will be able to apply for bail next month.
Katia was released on bail in July 2020. After more than 4 years in jail, she says there were some obviously wonderful things about being out on bail.
Seeing family and friends and seeing my cats, Ruby and Scarlet. They're from the same litter. I had them since they were babies from the shelter.
But she found it impossible to relax into her newfound freedom. Even though her successful appeal had stymied prosecution efforts to increase her sentence, the public prosecutor was already preparing the groundwork for another, fifth attempt to have her found guilty of Elia's murder.
I kept on thinking, okay, it may look good, but then any bet something's going to happen and the police are going to do something to F it up and make it look bad.
But in the meantime, something completely unexpected happened. I'm pulled over outside a big, nondescript warehouse in an industrial estate in Melbourne's western suburbs. It's Victoria Police's Archive Services Centre, the place where millions of police records go to die. Normally, the warehouse stays well out of the news, but in January 2020, it was at the top of news bulletins after the missing diaries of former Victoria Police Chief Commissioner Simon Overland were found in a box labelled miscellaneous, just weeks after he told the Royal Commission into Police informer, lawyer Nicola Gobbo, those diaries didn't exist.
They've prompted Mr Overland to change various parts of his evidence about Nicola Gobbo.
I didn't think I'd kept a diary.
In your first statement where you say that you didn't know at all, well, that's clearly wrong.
Well, I have accepted that it is
So
wrong.
refreshed his memory on whether Christine...
6 months later, in June 2020, just weeks before Katia was released on bail, the Police Archives Centre had given up more buried treasure. There it was. Detective Warren Ryan's missing police diary. The one in which Ryan claimed to have made notes about Sue Reddy recanting her confession about assaulting Elia. For the prosecution, it was more like a time bomb.
I was really blown away. I thought to myself, why did it take so long? If they existed, where were they this whole time?
That's the moment when the prosecutor should certainly do a complete review of the case and not just say, can we still make it through, but should we?
You couldn't make that up, and that is entirely remarkable. But I suppose reflecting on it now with you, I would say the one part that is unremarkable is that unfortunately Victoria Police do have that habit of not finding documents until the very last minute. This is an extreme example of that.
That's lawyer Jeremy King, who's now representing Katia. You'll hear more from him later. Before him, Professor Gans. So what was in Ryan's diary? I'll let Ryan explain for himself in a moment, but I can tell you that the contents of his diary, what it said and what it didn't say, were pretty staggering. Enough for Katia's legal team to go on the attack and launch an audacious legal bid to end the prosecution's fifth trial before it could begin. It'd be great for our listeners if you could just give an overview or a description of what a stay application is and why in a murder case the threshold or the bar is so high for one to be actually upheld.
So a stay means a stop, and it's a power every court has whenever anything's before them to say, this process needs to stop. It's not an acquittal, it's not a conclusion of any facts at all. It's just, you've come to the courts to solve a problem, in this case, to work out whether someone should be punished for an alleged murder. And the courts can't help you anymore. Things have gone so out of control that the courts cannot do their job.
Basically, a stay is what happens when the process of justice breaks down. It's the system's attempt at damage control. Remember, from the outset, I've said this podcast isn't about proving Katia's innocence or guilt. It's about whether she got a fair go. Was the principle of doubt properly applied? I'm also going to give you my best take on why I think Katia was at Elia's house that day and why she's never said anything about it. I'll do that in an upcoming episode. Circling back to her application for a permanent stay on the murder charge, Professor Gans reckons it's a sign that somewhere along the line, something's gone horribly wrong with Katia's prosecution.
With lawyers for the former McDonald's worker arguing there cannot be a fifth trial. A permanent stay is now necessary.
Professor Gans.
You're basically asking the courts to say that they're incapable of doing their job in this case, and that's a big call.
Succeeding in a stay application is never easy, particularly when it comes to murder. But on the 12th of October 2020, Katia's barrister, Dermot Dan QC, set to work before Victorian Supreme Court Justice Elizabeth Hollingsworth.
All stand, please, and remain standing. All persons having business before this honourable court are commanded to give their attendance, and they shall be heard. Be seated, please. The Director of Public Prosecutions against Katia Piliotis.
Yes, Miss Ellis.
If it please the court, Your Honour, I appear with my learned friend, Ms. Golding.
Thank you. Yes, Mr. Dan.
The court pleases I appear with my learned friend, Miss O'Brien, on behalf of Miss Piliotis.
He had Detective Ryan, now with Queensland Police, in his sights.
What I was putting to you, sir, was that up until this year, when your missing diary was discovered, you have consistently given evidence that you recorded this conversation with Miss Reddy in your police diary, haven't you?
Yes.
So on the voir dire in the second trial, you gave that evidence. You agree with that?
Yes.
A voir dire is a pre-trial hearing to determine the admissibility of evidence.
In the third trial, you repeatedly indicated that the conversation was recorded in your diary.
Yes.
And in the fourth trial, you repeatedly gave evidence that the conversation was recorded in your diary.
Yes.
Yeah. And so you accept, do you, that each time you gave that evidence in those various trials, that was false evidence?
I don't accept it was false evidence. It's, again, that was my memory of the conversation where I recorded the contents of that conversation, and it still is. But obviously I've been mistaken and I've recorded that in another format.
The thing is that when Katia's defence team finally got to see what was inside Ryan's police diary, they immediately searched for the reference to Sue Reddy, telling him she'd invented her confession to her Uralla carer, Ross Bracken. What they found was absolutely nothing.
Yeah, well, therefore it's false. It's wrong.
False mark conveyed to him deliberately. It's untrue. Untrue is neutral and doesn't suggest
Next,
otherwise.
Dan said about dismantling the evidence Ryan had repeatedly given in Katia's various trials, that the conversation he'd had with Sue, where she withdrew her confession, had taken place in the days after October 3, 2005, in the familiar surrounds of the Safeway supermarket car park in Kew. Ryan had been adamant about these details.
So what we have by you is a nomination and specification that this conversation with Reddy, where you say she recanted her confession to Bracken, takes place within days of the 3rd of October, correct?
Yes.
Yeah.
But as it transpired, during the course of Katia's third trial, Ryan had become aware that there was no way Sue could have recanted her confession in the Kew supermarket car park in the first week of October 2005, as he had testified. This was because it emerged she'd already been moved to a secure justice facility for people with disabilities in the suburb of Bundoora, 18 kilometres away. Nor did records show any evidence of Sue having left the Bundoora home unescorted or being visited there by police during the period of time Ryan had nominated. From this point on, Ryan progressively became less certain of his timeline. In fact, in his most recent statement to prosecutors, made in 2020, he pushed the possible date of his conversation with Sue out by 6 months to March 2006.
And what I suggest has occurred since is an attempt by you to shift the time frame in which this alleged recantation is said to have taken place. What do you say about that?
No.
This discussion took place with Ryan, trim, bespectacled, and with a cleanly shaven face and head, under oath, and in the witness box via a somewhat temperamental video link to his home in Queensland.
Witness, what is your full name?
Warren Dwayne Ryan.
Please repeat after me. I solemnly and sincerely
I solemnly and sincerely
declare and affirm
declare and affirm
that the evidence I shall give
that the evidence I shall give
will be the truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
And just before we move, I'll see if my associate can move so that Mr. Ryan is...
Ryan's troubles recollecting things and keeping his story together led to some interesting discussion about the difference between memory and reconstruction. Because in court, only one of these is acceptable.
If this is the situation you left in, if you had no independent memory in respect to when it was this conversation was meant to have taken place, why did you nominate that it was within days of the 3rd of October? Why did you start out with that time frame?
Oh, that's when I thought that conversation did take place. But obviously, I could be wrong. I could be right. I'm unsure.
I'm sorry, you confused me. Mr. Dan might clarify this. I don't understand. Is your current statement meant to say you now think it's March, or is your evidence still that it might have been in October? You've lost me. What is your independent memory, not your reconstruction? What, if anything, do you remember at the moment about how long after the 3rd of October the alleged recantation took place?
My answer is I don't know.
Ryan wondered if maybe he hadn't recorded Sue's recantation in his diary after all. Maybe it was in his police daybook. Justice Hollingsworth, a former University of Western Australia rower, Rhodes Scholar, and head of the Supreme Court's Criminal Division, was sceptical. She wears glasses and has short blonde hair, parted in the middle. Court footage of Katia's hearing shows Hollingsworth rarely sits still as she scribbles notes, rifles through documents, and punctuates proceedings with a commanding tone.
Are you saying you have a memory of this, or are you just speculating?
No, I'm speculating.
Yeah, well, I'm not interested. Please understand, I'm not remotely interested in your speculation about anything. You've done enough speculating in this case. I want to know what you can and can't remember. Do you understand?
In any case, Ryan's daybook, just like his diary had been until recently, was missing. Dan continued to pressure Ryan by asking him if he remembered telling the leader of his homicide crew, Detective Lucio Robus, or fellow investigators, Detectives Newman and Argyle, that Sue had taken back her confession.
My memory is that I shared it with Robus and Argyle.
Right. Well, what about Mr. Newman?
I'm unsure. He was heavily involved in the investigation. That's a possibility, but again, that's speculation.
Justice Hollingsworth was having a hard time keeping her patience.
Mr. Ryan, I don't want to have to keep reminding you. You've given evidence often enough. You know what you're being asked here. You have given evidence at previous trials that you told Rovers. Did you, in fact, have a memory of telling Rovers, or were you just reconstructing in those earlier trials?
Reconstructing in what sense?
Working on what you think your usual practice is rather than giving evidence from an actual memory.
Yes.
Reconstructing in the usual sense of reconstructing.
Yes.
Watching Ryan stumble through his increasingly impossible story via a video link was Katia.
Ms. Piliotis, can you just wave if you can see and hear us all okay? Thanks.
Yes, I can. Thank you.
Thank you.
I can see everyone on the screen. I may just need to raise my camera because I seem to be...
She didn't know what to think or how to feel about what she was hearing.
I was angry but relieved. Angry because if they existed, they hadn't been found sooner. Relieved and happy that they did exist, the fact that they were found and that they existed and that they were in the right hands and that they could benefit me, that was great.
Things were about to get worse for Ryan.
Look, I just want to take you to the diary entries that have now been located. Have you got those with you?
I do,
there?
yes.
Dan took Ryan to an entry he made on September 28, 2005, the day he and other police twice interviewed Sue before returning her to her Uralla home in Kew.
Next entry, Reddy provided further info re her relationship with Abdul Messi, admitted assault and sexual relationship with Abdul Messi. See that there?
Yes, I do.
What was the assault that she admitted?
I'm unsure. I don't have an independent recollection of what she said, and I'm only relying on the entry in my diary.
Well, this is a person that's about to be interviewed in respect to a murder, correct?
Yes.
Who admits, there's a note there. Seemingly, she's admitting an assault of Mr. Abdulmessi.
Yes.
According to those notes. But what you say, you just cannot remember anything about that.
Yeah, I don't have an independent recollection of her saying those words, but yes, she was formally interviewed the same day.
But if she'd said those words, you would have shared them with your colleagues, wouldn't you?
Possibly, and possibly I did.
Hang on, let's just rerun that.
Reddy provided further info re her relationship with Abdulmessi, admitted assault and sexual relationship with Abdulmessi. You see that there?
Yes, I do.
Dan took Ryan to a passage in his diary concerning the events of the evening of September 28, 2005, when he and other detectives returned Sue to the Urella house on Cotham Road in Kew. Remember, what you're hearing is Dan describing what's written in Ryan's diary concerning a vivid recollection by Sue of her attack on Elia. It goes way beyond what she said in her rambling police interviews earlier in the day, and even further than what she confided to her carer, Ross Bracken, that same night.
You've got to Cotham Road Kew, and at Cotham Road Kew, the note indicates Reddy admitted that she had assaulted Elia in his home on 18/9/05. Is that correct?
Yes.
How was she able to nominate that particular day? 18/9/05.
I don't recall the conversation, so I have no idea how she came up with that date.
It would have been significant that she'd been able to nominate the specific date because there'd been some earlier confusion about when she was last with Mr. Abdulmessi in her other conversations with police on that day, correct?
Yes.
So it would have been significant that she was able to nominate the actual day of the murder as the day of the assault.
Yes.
But you don't know now, you can't explain the way she did that or the terms in which she nominated the 18th of the 9th.
No.
So not only did Ryan's diary not support his sworn evidence that Sue had recanted her confession, it actually showed he'd made notes about a conversation in which Sue told him she had assaulted Elia on the 18th of September, the day he died. Dan continued.
It goes on, after they had sex and she was to be paid $20. Reddy stated that she had used the statue of Jesus to repeatedly hit Elia and that she was very, very angry and drunk. The statue of Jesus, or a religious statue, would have been very, very significant to you as well, would it not, if that had been said to you?
Yes.
Because that was, even at that stage, nominated a religious statue, a Virgin Mary statue, as the murder weapon or a potential murder weapon, correct?
Yes.
So the circumstances in which she nominated the statue of Jesus or the religious statue, can you tell us about that?
No.
Reflect for a moment on what you've just heard. It's bloody explosive stuff and of enormous consequence to Katia's position as the accused. Here was a diary record of a direct confession to Ryan, the detective leading Elia's murder investigation. Dan pressed on.
If you go back to your notes, at the end of that conversation, which finishes in these terms, according to the notes, stated she was remembering more and more about the assault, stated the assault took place in lounge and she hit him repeatedly and it was a statue of Jesus.
Yes.
Then the next entry is spoke to Ross Bracken, then informed him of the situation and requested he keep welfare checks of Reddy. So does that indicate that you told Mr. Bracken about this confession that Susan Reddy had made to you?
I'm unsure.
Or do you say, look, I just can't remember?
Well, I'm sure we told him to, because it says in my notes that we asked him to keep an eye on her, given that she'd been interviewed for a serious offence. What I actually said to him, no, I can't recall.
Mr. Ryan, this confession, what she told you, was very, very significant. And that's probably understating it. You agree with that?
Yes.
Not only was it confession, but it was a confession that involved detail. significant detail or very important detail about the use of religious statue, correct?
Yes.
By a person who'd just been interviewed in respect to the charge of murder, yes?
Yes.
Yeah. You would have told your colleagues about that confession, would you not?
I would assume so, yes.
Yeah.
Dan took Ryan to the part of his diary where he made notes of a call from Ross Bracken during the night of 28 September 2005.
Contacted by
21:35, yes.
Ross Bracken. Can you tell from your notes where you say you are at that time? 21.
No, but, I believe we're at the homicide squad offices.
So you're contacted by Ross Bracken, who stated he had spoken to Reddy, that Reddy had confessed to assaulting a liar with a blue and white ornament. Sorry, I'll read that again. To assaulting a liar with a blue and white, the word statue is crossed out, placed by ornament.
Yep.
And that she beat him around the head until he fell to the floor. She then left the address after washing her hands because she had blood all over her hands and face.
Yes.
Now, that's something that Mr. Bracken told you, is that correct?
Again, I don't have a recollection of that phone call, but I don't doubt that phone call took place, and that's what he said.
So you've got no memory of that conversation?
No.
According to Ryan's diary, Sue had even nominated the right colour for the Virgin Mary statue, blue and white. If you're anything like me, you're probably thinking, how could a crew of experienced homicide detectives have stuffed up a liar's murder investigation so badly? Another thing I'm left wondering is how on earth could Sue have known the detail about the religious statue being the murder weapon if she hadn't been at a liar's house that day? Ryan had an explanation of sorts.
I don't know. I know the statue of Jesus was put to her in her interview with Detective Newman, but
Yeah. How do you know that?
I've since read the transcript.
For what purpose?
To refresh my memory.
About what?
About what was said in the interview.
About how she may have been able to nominate a religious statue as being a murder weapon. Was that the purpose of refreshing your memory of an interview that you weren't part of?
No.
Why did you, when you made your statement this year about this entry in your diary, why did you suggest that this religious statue had been put to her in the record of interview? Why did you include that in your statement?
Because it had been put to her in the record of interview, and I wanted to establish whether she'd been truthful in what she was saying or whether that information had been provided to her.
When?
During her record of interview.
This year, when you look back on the record of interview, you wanted to establish whether she was being truthful.
What Dan was driving at here was that when Ryan's diary was found in June 2020 and it contradicted everything he previously said about Sue's confession, prosecutors had him swear up a new statement in an attempt to clean up the mess. And in this new statement, Ryan came up with the theory that maybe Sue was able to nominate the religious statue as a weapon because Detective Newman had suggested it to her in his interview with her at the Homicide Squad office in St Kilda Road, Melbourne. We'll hear from Newman on this later on. Back to Ryan and Justice Hollingsworth.
But you're not the judge here. You're supposed to be giving evidence of what you remember, not putting arguments for the prosecution. I think you're being asked, why were you trying to explain to the court something about an interview you had no part of?
I'm just being honest about what I did. I mean, perhaps I shouldn't have.
I've been in the witness box before in the Supreme Court of New South Wales when a businesswoman I'd written some unpleasant stories about wanted to know who my confidential sources were. I was grilled for hours at length by her smart and aggressive senior counsel. He even called me a liar. So I have some sympathy for Ryan. Cross-examination isn't easy. Before I appeared in court, a friendly lawyer offered me some advice. Answer only the question you've been asked, not the ones you think might be coming next. I'm not sure if Ryan got the memo, or, if he did, he paid attention to it. Katia's barrister, Dermot Dan, challenged Ryan to find the section of Detective Newman's interview with Sue in which Newman, as Ryan claimed, had suggested a religious statue as the murder weapon.
Have you found it yet, Mr. Ryan?
No, I haven't started looking. Would you like me to start?
Yes, no, start looking. You're supposed to be looking for this because we're not moving on until we've addressed this issue.
We're going to pause Katia's stay application at this point and rejoin it next episode where things get even weirder. Next time on The Confession.
I have serious issues about Mr. Ryan's credibility, and I may well find that he's an outright liar.
If he wasn't telling the truth about the diary, what else is he not telling the truth about?
I've formed the view that she had no involvement.
The Confession is written and presented by me, Richard Baker. Our story consultant and co-writer is Kate Cole-Adams. Julia Carr-Katzel is our producer and editor. Director of podcasting is David McMillan. Tom McKendrick is head of audio. Michael Batchelard is The Age's investigations editor. Sound design and mix by Kyle Hopkins. Technical assistance from Cormac Lally. Check out The Age and Sydney Morning Herald website for bonus material and for more of Australia's best investigative journalism. And if you've found any of the content of today's episode troubling, please contact Lifeline on 13 11 14.